Let me acknowledge the resource persons who are here today. Okay. From the Department of Finance, Mr. Secretary Cesar Purisima. Good morning, sir. From the Department of Energy, Mr. Secretary Carlos Jericho Petilla. Good morning, sir. Also from the Department of Finance, Yusek Jose Reverente. From the Department of Energy, Mr. Jose Raymond Acol. Are you around? Okay. Good morning, sir. From the Department of Budget and Management, Secretary Florencio Abad. Good morning, sir. From the NAPOCOR, Ms. Gladys Santarita. Good morning, ma'am. From PISAM, Mr. Emmanuel R. Ledesma Jr. Good morning, sir. VP for Finance of PISAM, Ms. Lourdes Alzona. Morning, ma'am. From the Office of the Solicitor General, Attorney Maximo Paulo Sison III. Good morning, sir. Okay, let me read the resolution. Resolution directing the Senate Committee on Energy to conduct an inquiry in aid of legislation into the 62 billion payables owed by the National Power Corporation and the Power Sector Assets Liability Management Corporation to displaced or separated NPC employees purportedly based on the Supreme Court's decision and resolutions in the NPC Drivers and Mechanics Association, also known as NPC DAMA versus NPC, with the end in view of formulating measures to address the same. I understand that the effects of the Supreme Court resolution, if upheld and pursued until its final consequences, will have dire consequences on our economy and our power sector. At this point, I understand there's a presentation, and I understand the Office of the Solicitor General will make the presentation. Am I correct? Secretary Purisima?
Mr. Chair, I will start the presentation, and I will be supported by the Office of the Solicitor General on the legal matters.
Okay then. Secretary Purisima, please proceed. Can we have the lights dim so that... I understand this is a PowerPoint presentation.
Yes.
Yes.
Thank you, Mr. Chair, and thank you for calling this hearing on this very important issue. Let me just give a brief background of the case. In 2002, EPIRA law was passed, and it mandated the restructuring of National Power Corporation. The National Power Corporation of the past was actually split into several entities, and to do this, employees had to be moved or retired. No? As we will see later, the bulk of them were rehired by the surviving entities. No? In 2014, the court sheriff demanded from NPC PISAM a payment of 62 billion, and a notice of garnishment of their assets was also issued. No? Now, let me go back to when they were retrenched. No? When they were retrenched in 2002-2003, no? A total of 9.09 billion was paid to all the employees, or an average of about 1.09 million each. No? This is about 1.5 months pay, as opposed to what the law requires, which is about half a month pay. In fact, in some discussions with Senator Osmeña, he said that the Senate interest was actually consulted then on the amount of the retrenchment pay. No? Out of the 9,021 employees that were affected, 7,127 employees were rehired by NPC, PISAM, and Transco. The others retired. No? In fact, of the 7,127 employees that were rehired, some were rehired immediately the next day after they were retrenched from Napocor, some a month later. No? The important thing to point out, though, Mr. Chair, is that all of them were paid a severance pay, and of the 9,021, 7,127 were rehired. No? So
excuse me, Mr. Secretary, you mean some were 9,000 were retrenched,
yeah,
and then some of them, 7,000, were rehired the next day?
3,300 were rehired the next day.
3,300 were rehired the next day
And
after receiving 1 million
after receiving the severance pay
of approximately a million
on average.
on an average.
Yeah.
Thank you.
And
Please
then
proceed.
5,800 were rehired within a month's time. No? So in the next slide, we're going to show a sampling of how much employees received. No? So this is just a sampling of some of the payments that were given at the time. No? Now, how much additional compensation do the DAMA employees demand? No? The total, actually, based on the court decision, is 60.2 billion for the employees. This is an average of about 7.5 million per employee on top of what they already have received before, and the salaries that they have been earning since then. Now, because a lot of them are still with the Napocor, PISAM, and Transco. Of the 60.2 billion, 6 billion will be lawyers' fees for the two lawyers that represented the employees. No? And the court fees is 1.8 billion, which brings it to 62 billion pesos. No? So the question, Mr. Chair, is are we liable to pay the DAMA employees 62 billion pesos? No? The only basis, based on, and correct me, Soljan, if I'm wrong here, on the decision is that the board meeting of Napocor, when the retrenchment was approved, no, did not have enough principals in attendance. No? I think that is the only basis. No? But as is standard practice in government, they are represented by duly authorized alternates. Plus the fact that I understand subsequently after that board meeting, the principals themselves in next meeting affirm this retrenchment. No? Plus the fact that the retrenchment was also only in accordance with what the IPIRA law provided. So that is as far as we see, the only basis why they're now saying that the government will have to shell out 62 billion pesos. No? Just to show the magnitude of 62 billion pesos, that's almost the budget for the conditional cash transfer program for a year, covering over 4.3 million families. No? And this is no joke. We believe that this is not a necessary expense of government and has no basis at all. No? Now, if the garnishment is implemented, no, how will this affect the public? No? Now, if the sheriffs insist on garnishment, we believe that potentially it can trigger a cross default of the existing 329 billion loans PISAM. No? And this can be called immediately. No? And this can result to a domino effect on other debt of the government. That's why we instructed the board that this needs approval of Congress as well as COA. No? Now, the 62 billion will only have a few places to go. Either it goes to the consumers or it goes to the taxpayers. It has nowhere else to go. So
At this point,
yeah.
excuse me, I'd like to acknowledge the arrival of Senator Serge Osmeña. Good morning, sir. Please proceed,
Yeah.
Mr. Secretary.
So if PISAM were to absorb it, we believe that based on a rough computation of the team, it will result to an increase in universal charge of 0.2122 for Luzon, Visayas, and Mindanao. No? Obviously, if we allow a cross default, which we will never allow, no, it will also create additional cost. No, a cross default, of course, is a worst case scenario assumption. No, but being the financial manager of the government, we cannot allow that because it will affect our credit rating moving forward. No? The next slide only emphasizes what I mentioned earlier, what 62 billion can buy us if it were not used for this purpose. No? At this point, I'll turn over the presentation to the Solgen, who will now walk us through the timeline of events. Thank you, Mr. Chair.
Thank you. Attorney Sison.
Good morning, Mr. Chair. So, the background of this case, as Secretary Purisima said, is the implementation of the IPIRA, which reorganizes the electric industry and privatized Napocor. And so, I would like to start with the 2006 decision of the court. The court there ruled that, the court ruled on a procedural question. It's a question of the validity of the NPB resolutions which provided for the separation plan of the NPC employees as mandated by IPIRA. And we should note that the NPC employees, NPC Dama, the petitioners in that case, filed the petition for injunction only against the NPB resolution, on the ground that there was no majority in the board, and the court ruled that the court granted the petition for injunction of NPC Dama and ruled that the members of the NPB cannot send alternates, as discussed by Secretary Purisima. So we should note that the petition for injunction was only against the board resolution, and it was only until 2008 via a motion for clarification by the NPC board, NPC Dama, which they prayed for a declaration of illegal dismissal of the employees. So it was not that declaration of the 60.2 billion, which is back wages, wage adjustments, and other benefits, were not in the petition. And it was only in the 2008 decision where the court granted the motion for clarification of the NPC employees. And then there were several decisions of the court with regard to the implementation. In 2008, the court issued an entry of judgment in this case. And yes, the latest resolution of the court, well, the latest substantive resolution of the court was now under the new ponente was denied the
Was there not a in October 2008? I understand that the 2006 and 2008 judgments became final,
yes, Your Honor,
final and executory.
final and executory.
And then in January 2010, the Supreme Court said, "Oops, teka muna, we'll issue a status quo order."
Yes, Your Honor. Yes, Mr. Chair.
Okay. Sige, please proceed.
So after the 2014, which the theory of the Solicitor General when we filed the motion, manifestation and motion, is that this should be referred to the en banc because by virtue of the internal rules of the court itself, this is considered as an en banc case. And one of the instances where a case is considered as an en banc case is where a judgment or a case has a huge financial impact on businesses and the welfare of the community. And the second point in that manifestation is that the Supreme Court has no original jurisdiction to rule on the illegal dismissal of employees. Because as we recall, it is only in 2008, after the 2006 decision, where the court ruled in favor of the NPC employees in terms of back wages, wage adjustments. In other words, it was only in 2008 where they ruled that the employees were illegally dismissed. That's why we mentioned that in the original decision, it was only a procedural question as against the resolution of the court. So, because of this manifestation and motion, the latest resolution of the court was the deferment of the implementation and the lifting of the notices of garnishment.
Na-lift a notice of garnishment?
Yes.
Okay. And you're appealing now, the state is appealing to the Supreme Court to have it considered en banc,
Yes.
these issues.
Yes. So there were 3 points. First is to consider to declare that the case is an en banc case, that the court has no jurisdiction to rule at the first instance because under the Constitution it belongs to the Civil Service Commission on the illegal dismissal of public employees. And third is with the substantive issue with respect to the first decision on the authority of the NPB members to send alternates.
Yes, I understand that this is a common practice in government corporations all over, that especially mga ex officio, that they always send a representative. And so, if this were upheld, it would have far-reaching consequences with all the board resolutions that have been passed in all the government corporations, where all the alter egos have signed in representation of the actual secretaries. Secretary Purisima?
Mr. Chair, that's quite true. In my case, no, I think I am an ex officio in over 30 entities. No, a good example would be the Land Bank of the Philippines, where I chair the board. There are several other ex officio members, that is Secretary of Agriculture, Secretary of Agrarian Reforms. We comprise majority of the board of Land Bank. And normally it is our alternates who sit for us. They are legally designated alternates. So imagine if this is upheld, Mr. Chair, then all the loans that were approved by those during those meetings would not have validity. So what would be the implication on a bank like the Land Bank?
Okay. So that's where we are right now. We have a situation where, pursuant to the EPIRA, 9,000 employees were separated. They received an average of 1 million pesos each. And then a majority of them were subsequently, in a very short time, rehired. And then the Supreme Court declared that the board resolution authorizing their separation is void because of the issue of the ex officio alternates. And therefore, we're in a situation today where the government might, until it's final, might have to pay the 62 billion pesos. Maybe we should really more look into what would be the consequences if the government were to pay, forced to pay, out of judgment, the 62 billion pesos. Secretary Abad, would you like to add anything to this?
Well, Mr. Chairman, good morning. Well, before we even assume that the 62 billion pesos is the rightful amount that the government needs to pay, I think we should really look into why 62 billion pesos. Because if you go by the presentation of Secretary Purisima earlier, please note that the employees receive 1.5 months separation pay for every year of service. And that's a total of 9.09 billion for 9,000 plus employees. That's only 9.09 billion. Now, 1/3 of those 9,000 plus employees were hired the day after that they were separated. And 2/3 were hired within a month's time from their separation. And at the same time, once rehired, they receive their salaries, and I presume certain benefits. So I was just wondering, if they were paid 9.09 billion at 1.5 months rate for every year of service for 9,000 employees at 9.09 billion, how did we come to 62 billion pesos when 1/3 were hired the day after and 2/3 were hired within a month? So what back wages and what benefits were lost within a period of 1 day or within a period of 1 month? So we will be very reluctant to consider this amount until we get the Commission on Audit, for example, to look closely into how this 62 billion came about, who were paid, how much they were paid, and what was the formula used for computing the corresponding back wages and benefits lost. Because we're just talking about if at all a month's pay lost by about 2/3 of the employees. I don't see how, if all of them receive 1.5 months pay for every year of service totaling 9 billion, I don't see how 1 month's pay for 2/3 of the employee would amount to 62 billion, Mr. Chairman. So I think that's the very first thing that we have to look at, because this is a highly questionable sum, Mr. Chairman.
So the first issue you're pointing out is the establishment of the facts. It seems that the premises by which the amount was arrived at are not clear.
Yeah, and this is just assuming, sir, that the legal arguments are correct. But as pointed out by the OSG, even the legal basis for the grant of the 62 billion is highly irregular or questionable, Mr. Chair.
Mr. Ledesma, would you care to add anything? What would happen to PISAM if you were made to pay?
Good morning, Mr. Chair. As Secretary Cesar clearly explained in his presentation earlier, garnishment would trigger acceleration of payments in PISAM's loan agreements, which is roughly around 329 billion pesos, or I think around $8 billion US.
So it would not just be 62 plus, it would be plus 300.
Well,
in effect.
In effect, yes, Your Honor.
Go ahead. What other consequences?
Well, of course, also the garnishment would lead to we would be unable to pay our capacity. And
are you going to make a presentation?
Well, we also have a presentation, but I think it's similar to the presentation of Secretary Purisimas.
Okay.
So I think it will just be
okay. Sige.
Ulitin lang po. So basically, what I wanted to add po is garnishment would also lead to we wouldn't be able to pay our other fees, including capacity fees, which includes fuel for all the plants, Your Honor. So everything, in simple terms, Your Honor, everything will be put to a halt, will be put to a stop in terms of PISAM's operations.
So, para sa mga nakikinig, pagka na-establish itong garnishment o puwersahin kayo sa pagbayad, mawawalan kayo ng pera para sa pagpapatakbo ng mga electric plants. Hindi na kayo makapagbili ng coal, yung fuel para sa mga electric plants. At dahil doon, magkakaroon ng brownouts, blackouts.
Opo.
At saan magkakaroon itong blackouts?
Total po. So, we're talking nationwide po.
Luzon, Visayas, at Mindanao.
Opo.
Yun po ang epekto. Yun
Yes
po ang
po.
epekto. What
Yes
else? What else?
Because like I said earlier, all our fees and capacity fees, especially the fuel, we will not be able to pay for. And then to add to that po, and then afterwards po, syempre if ever we get to pay that amount, like as earlier mentioned again by Sec Cesar, we will have to pass that on via universal charge. So again, national po yung effect, babayaran yan sa electricity bill ng mga taong bayan po.
So you're saying, syempre like what Secretary Cesar Purisima said, hindi naman papayagan ng gobyerno na mag-default, hindi ba? So talagang kukuha sila ng pera at yung pera na yan kailangan bayaran din.
Yes po, dahil hindi na po allowed yung PISAM umutang, so ang mangyari po doon, mag-on lending, national lending from DOF po. And then eventually, dahil lumabas po sa decision ng Supreme Court na universal charge stranded debt yan po. So eventually, ipapasa yan po sa taong bayan.
At kung ipapasa sa taong bayan, sa calculation mo, by how much will the electricity rates increase?
Kung over 10 years po, roughly around 26 centavos po. Kung over 5 years po, roughly 26 centavos. Kung over 10 years po, times 2, roughly
Gawin natin percentage sa Luzon, Visayas at Mindanao.
Kung percentage po, for Luzon, it's roughly over 5-year period, it's roughly 3%. For Visayas po, it's roughly 5%. For Mindanao po, it's roughly 7%.
3, 5, and 7.
Yes po. Actually po, we have on the board po. Yan yung breakdown po for Luzon, Visayas, and Mindanao. This one po is over a 10-year period po.
Over a 10-year period. If over a 5-year period,
can we flash over a 5-year period? Roughly po, for Luzon will be 7%, for Visayas 9.5%, for Mindanao 13.3% po.
What will increase, the universal charge or the total charge?
Yung percentage po, yung sinabi ko pong earlier, 7%, 9%, and roughly 13% for Luzon, Visayas, and Mindanao respectively, is an increase over the power bill po.
So, mangyayari dito, power bills, yung kuryente, yung bill ng kuryente na binabayaran ng bawat Pilipino, tataas.
Yes po, over the existing power bill yan po. So that's a percentage over the existing power bill. Yes po.
So, sa Luzon, tataas by how much percent?
7% po sa Luzon.
7%?
Sa Visayas po, 9%.
9%?
Sa Mindanao po, 13.3%.
13.3%.
Yes, Your Honor.
Mr. Chair, may I ask Mr. Ledesma, what would be the amount, the nominal amounts, instead of percentages?
Yes, Your Honor. Good morning, Your Honor. The total amount would be... Wait, Your Honor, can I clarify? Is it the total amount in cents of universal charge or the aggregate amount, Your Honor?
The total amount, you said that there would be an increase of 357%.
It's roughly 26 centavos, Your Honor.
So
26 centavos
the
for...
nominal amount to be charged on every customer would be the same, 26 centavos, except as a percentage of what they're paying now in their electric bills in the Luzon, Visayas, and the Mindanao, it would amount to 3, 5, 7, or 5, 10, 15, whatever.
Correct, Your Honor. And then just to restate, Your Honor, so for 5 years, it's 26 centavos. For 10 years, it's 52 centavos, Your Honor.
And you would have to collect this over 10 years.
10 years or 5 years, Your Honor, yes.
If it were 10 years, what would it be?
It's just, we'll just double the amount, Your Honor. So...
No. You're supposed to collect X amount. Why would you just double it? You mean to say...
Sorry, Your Honor, I meant divide by 2, Your Honor.
It's a straight line thing?
Yes, Your Honor.
All right, so it'll be 26 centavos if you collected it over 5 years, and 13 centavos if you collected it over 10 years.
Correct, Your Honor, but the numbers it's 52 and 26. Instead of 26 and 13, sorry, Your Honor, it's 52 and then 26. Straight line, Your Honor.
Okay. Thank you, Mr. Chairman.
Thank you, too.
Anything else as far as PISAM is concerned, Mr. Ledesma?
Nothing else, Your Honor.
Okay. Let's call on the NAPOCOR. Ms. Gladys Santa Cruz Santa Rita.
Good morning, Mr. Chair. We submitted this position to the Supreme Court, sir, and we said that if ultimately the DAMA claim amounting to 60.2 billion will be executed against the National Power Corporation, the missionary electrification program of the government will be compromised. This is the electrification of the islands off the grid.
Anong ibig sabihin ng compromise? Titigil?
Actually,
Para
there will be...
maintindihan ng mga nakikinig, titigil ba ang kuryente sa mga islang maliliit na sineservice ng NAPOCOR?
There will be brownouts, Mr. Chair.
Brownouts?
If not...
Mawawalan ng
blackouts.
kuryente. Yan
Yes,
ang ibig
sir.
sabihin ng
Yes.
brownout. Hindi po
Yes,
ba?
sir.
Saan po ito mga sinasabi niyong mga lugar na may missionary electrification kayo?
Currently, Mr.
Just give us
Mr.
some
Chair,
examples.
we service around 770,000 households in 207 municipalities across 35 provinces through our 296 small power utility group, SPOGs.
Bigyan mo
And
akong
these
mga lugar.
provinces include Batanes,
Batanes,
Romblon,
Romblon, Siquijor,
Catanduanes,
Catanduanes,
Masbate,
Masbate.
Palawan.
Yung buong Palawan po.
Yes.
So, lahat ng sinasabi mo, mga isla ito, di ba?
Yes, sir.
Oo. Pati yung probinsya ni Secretary Abad mawawalan ng kuryente.
Yes, sir. Including Marinduque, Mindoro Occidental, Oriental Mindoro, Dinagat, Camotes Island in Cebu, Calamansig in Sultan Kudarat, and we're also servicing the ARMM provinces of Basilan, Sulu, and Tawi-Tawi.
Okay. So roughly, we have a good idea kung sino mga communities maapekto nito at we all know that these provinces are not hindi mayayaman na lugar ito, no? At in fact, marami diyan na recipients ng CCT program. Tapos kung mangyari pa ito, mawawalan pa sila ng kuryente. Ano bukod sa mawalan ng kuryente yung mga isla na nabanggit mo, mga provinces?
Opo.
Ano pa bang mga epekto mangyayari sa inyo pagka napuwersa kayong bayaran itong judgment na ito? Bukod doon, ano pa?
Magsasara po ang National Power Corporation.
Ano pang
Dahil,
ina-administer ninyo mga programa?
right now, we're still managing the 7 Agus Pulangi hydroelectric power plants in Mindanao.
So, mawawalan kayo ng pondo. So, yung Agus Pulangi, where 55% of the electricity of Mindanao comes from, maititigil. Hindi po ba?
Yes, because
At
these are funded by PISAM.
Okay. So, magkakaroon ng malawakang brownout, hindi lang sa maliliit na isla, pati ang buong Mindanao.
Yes, sir.
Okay. Bukod doon, ano pang epekto nito sa atin? Na ang in charge dyan yung NAPOCOR.
NAPOCOR right now is also managing the 7 large dams in the country and the watershed, 17 large dam and 11 watershed areas in the country.
So yung mga watershed areas. Okay. Hindi ba kayo ang nagmamanage ng Angat watershed?
Yes, sir, including the Angat Dam.
Hindi ba yung karamihan ng drinking water ng Metro Manila galing sa Angat?
Yes, sir, more than 10%.
Okay. So klaro, mapanganib din ang supply sapagkat yung mga namamahala mawawala ng pondo para magkaroon ng operations sa watershed. Ganun po ba?
Yes, but we're in charge of the Angat Dam. Yung tubig naman po is now
Under the
private company
private
now.
company.
Yes.
Okay.
MWSS.
Okay. So klaro ang effect sa inyo at sa bayan kung maitigil ang operations ng NAPOCOR dahil dito.
However, Mr. Chair, per June 30 resolution, the Supreme Court held that the liability should be borne also by PISAM, so not only NPC. So hopefully, hindi naman magsara ang National Power Corporation.
Ang mangyayari talaga nito, hindi papayagan ni Secretary Purisima at yung ng gobyerno na mag-default ang PISAM at saka ang NAPOCOR at magkakaroon ng malawakan brownout over the whole country. Hindi pwede yan. So talagang mangyayari niyan, national government will have to step in. We'll have to foot the bill for these expenses. And the sad part is, ang masakit dito, yung consumer, yung mga mamayan, ang magbabayad nito through an increase in their electric bill. Secretary Purisima, you want to say something?
Thank you, Mr. Chair. In fact, that's going to be the ultimate effect. It will increase our already high power cost, which makes the country less competitive in attracting manufacturing companies to locate in the Philippines. Ang matatamaan rin naman nandito yung mga taong mababawasan ng opportunity na makakita ng trabaho. Ngayon po, our power cost is among the highest in the region already. Dadagdagan pa natin nito, which I really find unnecessary because the basis is questionable, the computation is also questionable.
Thank you. Secretary Pitilla, yung our power cost is among the highest in the region, as stated by Secretary Purisima. And if this becomes a judgment final, then we will have to pay this judgment, and the consumers, yung mga Pilipino, all the konsumante ng mga electricity, magbabayad nito by an average of a certain percentage increase in their electricity. Here we are trying to bring down costs, and this one will increase electric bills for all the Filipinos. Mayaman o mahirap, all the electric bills will increase because of this. Do you have anything to say on this matter, sir?
Thank you, Mr. Chair. Karamihan ng issues ay I think nasagot na ng ibang ahensya. Pero ang position naman ng Department of Energy is very simple. We are not questioning the decision of Supreme Court kasi ang sabi ko naman, kung kailangan bayaran ng mga tao, bayaran talaga yan. Ang question lang naman dito, tama ba yung amount? Yan ang kinokontest natin ngayon. Because if they really deserve this, talagang bayaran sila. But the question is the list final? 62 billion ba talaga? But I think this is a finance question na nasagot na ni Secretary Purisima at ni Secretary Abad. But I think ang more pressing issue, yung garnishment na naka-hold rin naman ngayon. Because yung na-issue yun, tinitingnan namin sa total capacity ng buong Luzon at Visayas, parang more or less 25% ng generating capacity in Luzon and Visayas will be affected. Ibig sabihin, titigil sila kasi ang sasabihin dito, Meralco, imbis na magbayad ka papunta sa Ilihan, wag mong ibayad sa Ilihan. Ibayad mo sa recipient ng Dama case. Pag nangyari yan, talagang titigil itong mga plantang to, they will not be able to pay for their fuel.
Para sa mga nakikinig, yung Ilihan po, yun ang isang power plant, na gumagawa ng kuryente dito sa Luzon.
Dito po sa Luzon at ito po ay under IPA na ina-administer ng PISAM ngayon at sila po ang nagbabayad ng gas. Kapag hindi sila nakapagbayad ng gas, hindi po tatakbo yung mga plantang yan. This is only an example, no? 25% in Luzon and Visayas. Sa Mindanao naman, bagamat 50% ng planta natin sa Mindanao is on hydro at yan ay pinapatakbo ng NPC, ang total assets naman ng PISAM doon na apektado kung hindi magbabayad ang mga kooperatiba kasi na-garnish is actually about 80% ng Mindanao. Hindi tatakbo yan. 50% is bad by itself, lalo na kung 80%. Kasi meron tayong mga diesel plant at saka coal plant.
80% of Mindanao's power plants will not run?
Will be affected po dito. Because meron po tayong coal plants, mga IPPs, saka mga diesel plants na under PISAM. Hindi lang po hydro. Pati rin po yun ay maapektuhan.
Hindi pwede to. This is very, very alarming. If you have 80%, might as well make it 100% and start manufacturing candles.
Yung po ang epekto, Mr. Chair, if ang garnishment is pinatupad. Kaya nga po kami kinabahan kaagad kasi ang outlook natin sa Luzon may kulang na nga tayo sa 2015 any megawatt na mababawas sa grid natin because of any disruption is talagang detrimental po.
So I think it seems clear, Secretary Purisima, Secretary Abad, that if the judgment becomes final, the national government will have to step in. The consequences as described by PISAM, by NAPOCOR, and Department of Energy cannot be allowed to happen. Am I correct?
Yes, Mr. Chair. And if we do step in, we will need the Congress to make an appropriation for this and for COA to approve the computation. Because these are public funds, so we cannot just pay. No? So Congress will in fact have to agree that this is something that is a proper use of government funds.
Secretary Abad?
Well, Mr. Chairman, if the legal basis for this judgment was based on the court's ruling that since majority of those who sat in the board were not principals but were representatives or designees of the principals, and therefore the board resolution that was adopted was therefore illegal. I think we have to revisit that decision because there is a Presidential Decree 2029 that was issued in 1986. And since this was issued during the time when the President then had legislative power, this is therefore law. Section 6 of that law with respect to ministry representation on governing boards states that any provision of existing law to the contrary notwithstanding, a minister or his equivalent who is by law designated as ex officio chairman or member of the governing board of a government corporation may designate a senior official of his ministry to sit in his stead, provided that where a minister is ex officio chairman, his representative shall be a deputy minister. In other words, there is an existing law that authorizes heads of department to designate a representative in the board meetings of government corporations. So therefore, there was basis for the non-principal designees to sit in the NPB and on by authority of their principals decide on board resolutions. So there is basis for this, and therefore, if that were the only basis for this judgment, then it is therefore highly questionable because there is basis for it.
Yes, Secretary Abad, I agree with you, and that is well taken. Thank you. Secretary Pitilla, of course, once the funds are raised to take care of the bill, should the judgment become final and it should be executed, then definitely someone will have to pay for this. Am I correct?
Tama po, Mr. Chair.
At yung magbabayad po nito, ang mga consumers. Am I correct?
Kung ipapasa po ito as universal charge, okay, as it is also defined in the decision of the Supreme Court na this forms part of the stranded cost. Therefore, kasi lahat ng stranded cost niyuyusin natin, universal charge, so ipapasa po ito kung ito ang susundin natin.
Para sa mga nakikinig at nanonood, ano po yung ibig sabihin ng stranded cost?
Stranded cost and stranded debt ay ito ang kautangan ng napokor na inassume ng PISAM na kung merong diferensya sa assets niya, sa halaga ng hinahawakan niya at saka sa mga gastusin pa na iba, ito'y ipapasa ngayon sa taong bayan. So ang diferensya po ng assets niya at saka ang liabilities niya, ito po ang magiging stranded cost natin. So this forms part of it po.
So this amount, whatever will be raised to take care of these charges, will form part of the stranded cost and will now be passed on to the consumers. All over the Philippines, from Luzon, Visayas, and Mindanao.
A uniform amount po sa buong Pilipinas. Although ang epekto kasi iba-ibang presyo sa bawat ibang rehiyon, ibang porsyento po pero isang amount lang.
Iba-ibang porsyento pero what is clear is that definitely electric bills will go up.
Kung ito po ipapasa sa universal charge, ito po itataas talaga.
Okay. Thank you. Thank you.
Can we go backwards, Mr. Chair? Secretary Purisima. You say you hold directorships in about 30 government-owned and controlled corporations. Am I correct?
Including councils and various bodies, yeah.
All right. Can you have your secretary draw up a list of all the meetings that you attended and all the meetings that you missed? No, I'm not trying to see how this could affect not only yours but everybody else's uh, performance, approval of loans, etc. So I want to see Secretary Purissima missed 70 out of 100 meetings. In these 70 meetings, these are the items that were approved and decided, and there was, under the Supreme Court decision, this would not have been valid because the designates in those meetings were in the majority. In other words, they were not, as per the Supreme Court decision, authorized to make those judgment calls on behalf of their principals. Diba? So I'd like to see how this approach will at least render it impractical to take the Supreme Court decision seriously, because then I'd like to know, what if somebody went up to the Supreme Court and said, oh, eto, di illegal lahat ito. And let them realize also the implications of their decision. So that's one. Two, I'd like all cabinet members to submit their presence and absences in the various GOCCs that they were they're supposed to be represented in. So I guess one of you guys will have to take up that piece of homework, so that we would have an idea on how much of these substitutes are really the ones that attend the board meetings during which all of these resolutions and approvals of budget are passed. Because I think this is how government is really run. I mean, I think it's almost impossible for a cabinet member to attend even the board meetings of 10 corporations. You just wouldn't have the time to do that. So essentially, government has been run on designates, by designates. And this reality has got to sink in, not only here in the Senate, but in the courts, wherever they are. Third, you have samples of employees, and you designated them as employee A, B, C, D, E. Now, these are real persons, right? Okay. Now, this employee A, for example, received 9,661,388 on a basic salary of 113,991. Now, that basic salary was when he left Napocor, or when he was rehired by Napocor?
When he left, Your Honor.
When he left.
Yeah.
And when he was rehired, he started to receive the 113,000.
I think we'll have to check that, but I think it was a little lower.
All right. And then now, with the implications of the Supreme Court decision, would be he would receive how much? Because there's a third amount involved. The amount that he collected, the separation pay, the 9 million, the amount that he has been collecting because he was rehired, and now the amount that is included in the 62 billion. So he's really gonna get paid 3 times, no? I'd like to know what that amount is.
We will submit that, Your Honor, but on average it's 7.5 million per employee. Yeah.
All right. So essentially, he was hired by Napocor,
Yeah.
and we're paying him 7.5 million because he should not have been fired by Napocor. That's what you're saying.
Yeah.
All right.
Yes, Your Honor. Yeah.
Correct me if I'm wrong.
Yeah.
So therefore, if he is now due to receive 7.5 million because he should not have been fired by Napocor, and today he's still working for Napocor, how does the court expect us to interpret that?
That is why, Your Honor, it's hard to reconcile all of this. Plus the fact that they were given severance pay in the first place. So severance
That's
pay
right.
rehired.
Wala pa ako doon.
then-
I'm just in the first two. I hired you, and now you're suing me because I let you go and hired you. But hindi ba advantage to you letting you go and hiring you because you got a separation pay of 9.6 million and I hired you again. So how are you disadvantaged? Now, I'm curious, how did something like this fall through the cracks? Who was in charge of defending this in the various stages of trial? Which agency?
Your Honor, it was the OSG for the National
It
Power
was
Corporation.
Excuse me, I cannot read your...
Your Honor, it was the OSG represented the National Power Corporation, and the OGCC represented PISAM.
Okay. So your predecessors flunked.
Your Honor.
Now, having studied their pleadings, having studied the previous decisions leading up to this, what mistakes were made? You know, we conduct hearings here in aid of legislation, and we want to know what mistakes were made, what corrections in the law
Your
should we
Honor,
propose in order to make sure that this doesn't happen again.
Your Honor, as mentioned by Secretary Abad, there is already an existing framework which authorizes members of the NPB or the National Power Board to send delegates. Even in the administrative code which was issued in 1987, it already authorizes secretary members to send delegates. And the law mentioned by Secretary Abad, and also even recently under the GOCC Act of 2011, members of the board, ex-officio members, are also authorized to send delegates. So it's really a government practice. And there is already an existing framework. That is why, Your Honor, we consider the ruling of the court to be particularly and also what is also very worrisome with respect to that ruling is the ruling that these board resolutions cannot be ratified. So even if there is a subsequent meeting which is intended to ratify the acts, it cannot be done according to the 2006 decision of the court. And if that ruling stays, then the effects, the costs, which are in this case back wages, wage adjustments, and other benefits, will be demanded from the government. So the 60, in this case, the 60.2 billion is a consequence of simply a procedural question, which is the authority of the members of the board to send delegates. But again, as mentioned, Your Honor, there is already an existing framework, a legal framework.
The legal framework you're saying
Is
was
the
brought
administrative
about
code.
after.
No, sir, it was before, because the administrative code,
Before
before the
2001?
decision. Yes, 1987.
1987?
Yes. If I may read,
And
Your
in
Honor.
spite of that, in spite of that, the Supreme Court decided the way it did.
Yes, Your Honor.
How long does it take the Supreme Court justice to read something that was written 5 years before? All
It
right.
will vary, Your Honor. If I may read the provision in the administrative code.
I'm quite upset there. If you say there was already a law that was passed in 1997
1987.
allowing that arrangement, and for the Supreme Court to now decide that no, it cannot be done, designates may not exercise the judgment in place of their principals, paano yun?
That is why we also included that substantive issue. That issue in our pleadings
What issue?
that the authority of the ex officio members to send delegates, because essentially the 60.2 billion is the consequence of that ruling, and it is only a procedural ruling.
Okay. And then what about the substantial effect of paying somebody 2 or 3 times? Does the court not take that into consideration? Okay, tama ka dito. You can collect this salary. But since you are already rehired and you collected that salary, there should be a process of elimination. Why would they allow double collection, even triple collection? Because sometimes the employee will have already received the separation pay.
Well, Your Honor, from a strictly legal point of view, if we follow the logical consequence of the court's decision, they're saying that because the resolution is void, from that moment when the resolution was issued and then the employees were separated, that period, they're entitled to back wages. So if we just pursue the logic of the decision, it doesn't matter if they received additional compensation or they were rehired, because from the moment that they were terminated and that it was an illegal termination, they are already entitled to all back wages and other benefits, Your Honor.
Yes. Again, at what point will the court, if it will at all, take into consideration that this guy occupied the same job and has been paid the same amount of wages that you are saying we owe him?
Well, yes, Your Honor, we included that in our...
This is a matter of equity, no?
Yes.
I think the Supreme Court will have to take that into consideration.
Yes, Your Honor.
Now, it would be different if this fellow found another job. I'm just concerned that this fellow is occupying the same position that he was supposed to have retired from, and now the court says you're going to have to pay him. And paano yan? I kept him in the same position, and I've been paying him the same salaries and benefits that accrue to that position, no?
Yes.
Wala pang comment ang Supreme Court yan.
Not yet, sir, but we included that in our submissions.
All right. The next question is, what about the Supreme Court detailing how the 62 billion is supposed to be paid? Meron ba silang detalya?
No, Your Honor, because the general rule is that the Supreme Court does not consider questions of fact, and that would those details would require...
That would fall on the Court of Appeals or the
trial courts.
The
or
trial court, the Court of
Court of
Original
Appeals.
Jurisdiction. Basta,
Yes.
ang sinulat ng Supreme Court, you owe 62 billion, ganun ba yun?
The Supreme Court did not declare 62.2 billion, but
How much did they say?
they did not say, in fact.
Where did we get the 62 billion?
It was from the demand letter of the clerk of
I
court.
see.
Because
The clerk of court of the Supreme Court or the clerk of court of the Court
regional
of
trial
Original-
court of
Original Trial
Quezon
Court.
City. Yes.
Yeah.
Because they designated the clerk of court of the Quezon City RTC to determine the amount.
All right. So the Quezon City Court now will be the one to decide.
It's not even, Your Honor, a court. It's a
Teka
clerk
muna,
of court.
I'm trying to nail down the 62 billion.
Yes.
What did the Supreme Court say? Nothing. It did not mention an amount. That's what you're saying?
Yes. Did not mention an amount.
So, iba itong 62 billion. This is the amount mentioned by the clerk of court
Clerk of
of
court.
the Court of Original Jurisdiction, which was the RTC.
Yes. The clerk of court.
But if it had not been so parang itatrial uli yan. Kung magde-determine po sila kung
Yes, Your
magkano
Honor.
ang utang kay Mr. A, B, C, D, E. Ganun ba yan?
to determine the amount, it would require receipt of evidence. But that's why we mentioned that one of our objections to the court's ruling is that they cannot determine at the first instance the fact of illegal dismissal, because in the first place they cannot, as a general rule, the court does not receive evidence, and they only delegated to the clerk of court. And that's why, Your Honor, we're saying that the 60.2 billion judgment award is only a consequence of the ruling on the sending of delegates.
All right. So it looks to me that you probably have a trial all over again because this is a question of fact that will have to be determined by the lower court.
It will require, Your Honor, a receipt of evidence.
So the only bone of contention that we would have, or you would have, with the Supreme Court is that why did you allow, why are you not allowing designates to vote and exercise judgment on behalf of their principals? Ayun lang.
Yes, Your Honor, and the fact that they ruled that the NPC employees were illegally dismissed at the first instance. Because we should take note that...
In this case, I'm not a lawyer, so
Yes.
in this case, when you use the phrase "at the first instance," what does that imply? What does that mean?
It means that it did not undergo trial in the lower courts. The Supreme Court ruled, well, at the first instance, it was the first instance that the Supreme Court ruled in that way, that the employees were illegally dismissed.
In other words, the question of fact had not been established by a lower court yet,
Yes,
and they came to the conclusion that they were illegally dismissed.
they were illegally dismissed.
But did they come to the conclusion that they were indeed illegally dismissed because the composition of the board was composed of substitutes?
Yes,
instead
Your
of
Honor.
ori-
Because the board resolutions were void and therefore cannot be ratified, and therefore they were illegally dismissed.
All right. Now, how would the Supreme Court now react if you showed them a deluge of various resolutions done by, how many GOCCs do we have? 600, 500? Done by that, and say which of these did you want to invalidate, because we're going to
Yes.
have to undo several decisions
previous
going back
acts.
30 or 40 years.
Yes.
I would like to see. I would like to see that such a presentation and the evidence, the amount you can compile. You don't have to show each and every one. I just want to know how many such decisions pertains to this corporation, that corporation, which would have been declared invalid under this doctrine enunciated by the Supreme Court.
Yes, Your Honor.
I think the Supreme Court must be made to realize the implications of their decision in this particular case. No? Now, starting tomorrow, or starting last week, or starting when this decision was handed down, have all the cabinet members been attending religion?
It's
I would like
Mr.
to know, Mr. Secretary,
Yeah.
have you been attending all 30?
Mr. Chair, it's physically impossible because this
No,
meetings,
just say, have
Yeah.
you been attending, yes
No.
or no?
No.
No, you have not.
In fact, the
So therefore,
answer, I
there have
think-
been several approvals done by some of those boards on which you sit that might be illegal under this doctrine of the Supreme Court.
The best example would be the Land Bank, Mr. Chair, which I am the chair, and there are several members who are ex-officio. I don't know how many loans they process a year. No, the loans will have to be approved by the board. So we're now going to declare all these loans invalid.
All due and payable.
I mean, no loans.
But you release the money, so
Yeah.
it should now be
So-
repaid.
So
No, these are the practical effects of a decision like that, no?
Just a clarification on the legal issue since the Solgen is here already. I'm being told that the case was never tried in an RTC or a Court of Appeals. It actually went straight to the Supreme Court. So I think the Solgen can clarify this with us.
Solgen?
Thank you, Your Honor. Just to provide everyone with a procedural aspect of this case, usually, Your Honor, cases that involve an evaluation of facts have to go to a trial process so that both parties can determine whether or not a particular fact is valuable for purposes of consideration of the court, and so that the trial court can weigh the presentations of the parties. In this particular case, Your Honor, the case was filed directly before the Supreme Court based on the facts as presented by one particular party. And so what we're saying, Your Honor, is that apart from the problematic legal conclusions rendered, with all due respect, by the Supreme Court, there are intricate factual questions that have to be resolved by the trial court, independent, again, Your Honor, of the question of whether or not representatives can attend, whether or not the separation was done in compliance with a legal obligation, with a legal mandate. And so what we believe, Your Honor, is that there are so many questions in this case that require the full court and bank to assess the manifestation that the Office of the Solicitor General filed 2 months ago. And so, Your Honor, what we're asking from the court is, given the amounts involved, effectively a 400 billion judgment, this has to be, by the internal rules of the Supreme Court itself, decided by the full court and bank. And ultimately, that the court reconsider our position on the legal question.
So it looks like that's your recourse now, to have the Supreme Court recognize that this requires an en banc decision.
Yes, Your Honor. In fairness to the Supreme Court, what they have done preliminarily is, in response to the manifestation and motion of the government, is to recall the order of garnishment, because, Your Honor, this case has already been entered in judgment in 2008, and so this is already, in the language of lawyers, over, and we're now at the execution stage, final and executory. But again, Your Honor, given the amount involved and the legal implications of the decision of the court, not only to the government institutions involved, but also to the other government institutions that might be affected by the decision, we're really trying hard to convince the court. And so, Your Honor, preliminarily, what the court has done is to basically issue a status quo order while they are considering the submission of the Office of the Solicitor General.
So we have the request that this representation made for all that information. It would be interesting to find out how many major decisions would be affected by this. We're not talking about one decision involving 62 billion. We will probably go up into the trillions if we add up all those decisions that could be under this type of arrangement be questioned as having been illegally approved. Now, There is another point that I wanted to bring up. The fact that there was a law, it was enshrined in the law, the intent of the government to pay a rather generous retirement pay to the employees of Napocor that would be laid off, and knowing that not everybody would be laid off. I mean, you know, if I recall, an executive of Napocor said something like 80% would be rehired anyway. How did that not affect the decision of the Supreme Court? Kasi parang technicality lang sa akin itong ginawa nila eh. Nakasulat na sa batas sa EPIRA. I know because I was there. I participated in it. I participated, as a matter of fact, in that particular how much to give them, because the law, if I recall, only mandated half a month, no? And we made it a month and a half of service for a year of service. So nakasulat na sa batas. So this was merely executing it. I think it would have been self-executory, would it have been self-executory even without an approval of the board of director? Because you already said pay it, diba? The only decision would be for the executives of Napocor to say he's rehired, he's not rehired. But the right of receiving payment was already enshrined in the law, or the right to pay was mandated by that law. I think Secretary Abad was a member of the BICAM when we were
I remember, Mr. Chairman, that your cousin
yes
almost violently objected to those
yes
provisions about
he does
rehiring and giving them a generous separation package.
Yeah, he does get violent once in a while. Yeah, I remember that, and he was outvoted, di ba? Okay. So, yung parang automatic na ito, bakit pa kailangan ng absolutely formal board of director? Because the board could not have overturned what was already written in the law.
If I may, Your Honor, we agree, Your Honor, that this was an act done pursuant to a legal mandate, and I think the policy is clear to try to give the NPC a fresh start. But I suppose, Your Honor, the practical purpose of that resolution also is to set the date for when the benefits would accrue, just to fix the date. But that itself would not be very important. Again, Your Honor, because what is important really is that there is a legal mandate, a congressional order on the part for the NPC to reset itself, right? And so it's not as if this was a highly discussed policy on the part of the NPB. This is, for the most part, a pro forma resolution, and I would surmise that the purpose of this resolution is just to set the date for when the separation benefits of these employees who were also rehired will accrue.
Now, I also have a question. Nakatanggap ako ng 9 million. Tapos question ko na yung board resolution ay hindi po valid. So I'm still shouldn't I first return the 9 million that I got plus interest? Huh?
That would be the logical thing to do, Mr. Chair.
So maybe they should all be asked to deposit already in escrow the amounts that were paid to them because that to me is therefore one-sided na sasabihin nila nakatanggap na ako ng retirement pero hindi pala ako retired. I sued and I won, so I'm not retired. So the next thing you want to say is, can you give me back the money that you collected? Di ba? All right. That's all for now. Thank you, Chairman. Thank you, dear.
Okay, since there are no more, there are no other senators that wish to ask questions. I think the issues are clear. We have a situation that will be very detrimental to the government and to the people if this decision is pursued to its full conclusion. And therefore, until further notice, this hearing is hereby adjourned. Thank you everyone for coming. Ish? Okay, ayos mo na.